Ladies and gentlemen, we start this webinar in the next 30 seconds. May I request all of you to please settle down. Ladies and gentlemen, Devior Sajjano, a very good afternoon to all of you and welcome to this exciting webinar being organized by the Center of Excellence on Alternative Dispute Resolution at Manav Rachna University, jointly with UNCITRAL RCAP, which is the UNCITRAL's Regional Center for Asia and the Pacific, and UNCCI, which is the UNCITRAL's National Coordination Committee for India. At the very outset, let me take this opportunity to thank Live Law and Rashid for being the media partners to this important webinar. Ladies and gentlemen, my name is Ajay Thomas. I'm the Director of the Faculty of Law at Manav Rachna University. And additionally, I sit as an arbitrator and also act as a national correspondent for India to UNCITRAL's cloud system. I'm delighted to be moderating this event with Shreyas Jayasima, who is somebody who needs no introduction. Shreyas is the embodiment of what I call the dispute resolution trinity. He's an advocate, an arbitrator, and also a mediator. Shreyas is the founder of Arna Law, which is a boutique law practice headquartered in Bangalore with offices in Singapore, Mumbai, and Delhi. Now, ladies and gentlemen, this webinar is the third in a series to be jointly hosted by UNCITRAL RCAP, UNCCI, and Manav Rachna University, which will be covering topics relating to the current work being done by UNCITRAL, which, as most of you would know, is a core legal body of the United Nations system in the field of international trade law. And UNCITRAL, as most of you would be aware, the objectives of this organization is to further the progressive modernization and harmonization of international business law. So, ladies and gentlemen, the theme for today's webinar is mediation as a tool for conflict management. Given that the Singapore Convention on Mediation will come into force in September 2020, this convention surely will have a profound impact on cross-border enforceability of mediated settlement agreements. And consequently, we believe that the importance and relevance of mediation as a method to resolve cross-border commercial disputes is only bound to increase. Some experts have predicted that the impact of the Singapore Convention on Mediation will be as transformative to the process of mediation as has been the impact of the 1958 New York Convention on Arbitration. The Chief Justice of Singapore, Mr. Justice Sundaresh Menon, in a speech a few years ago had said, and I quote Mr. Menon, "This present age of arbitration is in fact its golden age, and those amongst us who practice it are extraordinarily privileged to be able to do so," unquote. So if one were to juxtapose this statement of the Honorable Chief Justice of Singapore in light of the recent developments in the field of mediation, ladies and gentlemen, I would like to believe that the golden years of mediation are not too far away. And for today's webinar, we're privileged to have with us a stellar cast of speakers, which includes a former judge of the Supreme Court of India, one of UNCITRAL's leading mediation specialists, an experienced mediator, author, and professor of law, and last but not the least, a brilliant Singaporean lawyer who was very closely involved with the drafting of the Singapore Convention on Mediation. So here's a little more about our speakers. Our first speaker is Justice Madan Lokur, who is a former judge of the Supreme Court of India and who presently serves as a judge of the Supreme Court of Fiji. Justice Lokur joined the legal profession way back in 1977. He was designated as senior advocate in 1997. He's a former additional Solicitor General of India and has been a judge since 1999. While on the Supreme Court of India, it was written about Justice Lokur that he was the epitome of the four-way test propounded by Socrates, which is hear courteously, consider soberly, answer wisely, decide impartially. Ladies and gentlemen, Justice Lokur's name has been synonymous with mediation and its growth in India. He was a member of the Mediation and Conciliation Project Committee of the Supreme Court of India since its very inception, and in his capacity as the executive chairperson of the National Legal Services Authority, he steered the Indian judiciary's efforts to promote the resolution of disputes through mediation, conciliation, and lok adalats. Our next speaker is Judith Neiper, who is a legal officer at the Secretariat of UNCITRAL in Vienna. Until her appointment to the UNCITRAL Secretariat, Judith worked for 5 years in a law firm in Frankfurt and then for many years in Southeast Europe for numerous organizations, including the World Bank and GIZ. She's a qualified lawyer called to the bar in Frankfurt. She holds a PhD and is also qualified and certified to be a mediator. Then we have Dr. Nadia Alexander, who is an international dispute resolution specialist and is recognized as a global thought leader in the field of mediation. An award-winning author and educator, Nadia's expertise has contributed to the design and drafting of dispute resolution legislation in more than 10 jurisdictions, including Singapore, Hong Kong, and Vietnam. She's a foundation member of the International Advisory Board of the United Nations Global Mediation Panel, and presently Nadia is Professor of Law at Singapore Management University's School of Law, and she is also the director of the Singapore International Dispute Resolution Academy. Our last speaker for today is Natalie Morris Sharma. Natalie is director of the International Legal Division at Singapore's Ministry of Law. Previously, Natalie was a legal advisor to Singapore's permanent mission to the United Nations. She was also a deputy senior state counsel in the International Law Department of the Attorney General's Chambers. At UNCITRAL, Natalie's recent roles have included being the chairperson of UNCITRAL Working Group 2, which was responsible for the stellar work which was done by UNCITRAL in bringing to light the Singapore Convention on Mediation and also the amendments to the UNCITRAL Model Law on Mediation. Natalie was also vice chairperson of UNCITRAL's 50th Commission session. She currently serves as the rapporteur to UNCITRAL's Working Group 3, which, as most of you would be aware, is looking into reforms to the ISDS system. After that not so brief introduction to our distinguished speakers, may I now invite Atita Kominder. Atita, as many of you in Asia would know, is the legal officer for UNCITRAL's Regional Office for Asia and the Pacific. Now, before I hand over the mic to Atita, here's a little bit more about Atita. As the head of UNCITRAL's Regional Center for Asia and the Pacific, Atita manages technical assistance and capacity building programs to over 50 states in Asia and the Pacific. She spends a lot of time coordinating with governments and international and regional organizations on trade law reform activities and manages programs to promote the rule of law in commerce. Atita is admitted to the New York Bar. She holds degrees from Harvard and Georgetown and has experience in both common and civil law. Ladies and gentlemen, I now have the privilege of handing over the session to Atita Kominder for her inaugural opening remarks. Atita, over to you.
Many thanks for the kind introduction, Ajay. And good morning, good afternoon, and good evening to you and Shreyas, and to our speakers and webinar participants from every corner of the world. I'm Atita Kominder, and I head the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, or UNCITRAL RCAP, located in Incheon, Republic of Korea. It is my great pleasure to deliver co-welcoming remarks on the occasion of this mediation webinar, which is the first digital event on this critical topic to be co-hosted by UNCITRAL RCAP. This would not have been possible without the hard work and excellent organization of our partners, the UNCITRAL National Coordination Committee for India and the Center of Excellence on ADR at the Faculty of Law, Manav Rachna University. As you may know, RCAP is UNCITRAL's only regional center. We opened our doors in 2012, funded by the government of the Republic of Korea, and closely collaborate with Secretariat colleagues in Vienna to carry out UNCITRAL's work of promoting the progressive harmonization and modernization of international trade law in approximately 60 jurisdictions in the Asia-Pacific region, helping governments and stakeholders to overcome disparities in national legal systems, thus facilitating cross-border commerce and international trade across the world. UNCITRAL's current work program ranges from access to justice via mediation and arbitration, cross-border insolvency, judicial sale of ships, creating a legally enabling environment for small enterprises, which form the backbone of the majority of national economies, and e-commerce and the digital economy. UNCITRAL's most recent achievement is one of the topics of today's conference, the United Nations Convention on International Settlement Agreements resulting from mediation, or the Singapore Convention on Mediation. Mediation is, of course, on the rise in the Asia-Pacific region, and India was one of the largest economy original signatories of the Singapore Convention last August. One of my colleagues will be speaking on the convention today from Vienna, so I just wanted to give her a special shout out. She's legal officer Dr. Judith Nieper, or as she is known by us in the Secretariat, Madame Mediation. I would like to thank, on behalf of UNCITRAL and UNCITRAL RCAP, all of the speakers, the moderators, the co-organizers, for your invaluable contributions to a most successful and intriguing dialogue today. Thank you.
Thank you very much, Atita, for your very kind comments. This is, I do not wish to stay between you and the speakers, but I do wish to mark the occasion with a quick cultural recognition that in every faith and culture, the highest aspiration is peace, be it a form of greeting or a form of prayer. So with that, the burden lies then on lawyers and judges to translate that noble sentiment into meaningful reality in daily commerce, especially in conflict resolution. And to guide us first, we have Justice Madan Lokur. Sir, I invite you to now speak on the rise of mediation and conciliation in India. Justice Madan Lokur.
Yeah, thank you, Shreyas. And good morning, good afternoon, and good evening to all the participants and to my co-panelists and Ajay Thomas, Atita, and Shreyas. I would also like to thank UNCITRAL, the Regional Center for Asia and the Pacific, the Center of Excellence on ADR, Faculty of Law of the Manav Rachna University, and to UNCITRAL National Coordination Committee, India, for organizing this webinar. It's a great pleasure being here, and I hope I'll be able to contribute something about mediation in India over the last maybe about 15 years or so. As Ajay had mentioned, mediation actually took off in India sometime in August 2005. We had a group from the United States, from California, who had come to train some of our judges as mediators. And this was on the initiative of the then Chief Justice of India, who felt that mediation should be given encouragement. In fact, it was a part of our Civil Procedure Code, Section 89 of the Civil Procedure Code, but no steps had been taken to promote mediation. So this group from the United States came over, and they spent 6 months, out of which maybe about 3 weeks or so was spent in training, and the rest of the time was spent in organizing the mediation center and so on. So it started off, like I said, in August 2005. The road was kind of bumpy in the beginning, in the sense that the lawyers thought that by encouraging mediation, they would be put out of work. And so therefore, they were not very keen to promote mediation. The purpose of the mediation program was actually court annexed mediation, which is to say that cases that were pending in the courts would be referred to the mediation center, and the mediators, the trained mediators, would try and resolve the dispute. We permitted lawyers, of course, to appear for the mediation sessions, and I think this gave them a little bit of confidence that, well, maybe they may not be out of work because of mediation. It picked up pretty quickly, and we started off in one center in one of the district courts. But then the lawyers from some of the other district courts also said that, we would like to have a mediation center. And so therefore, we permitted that, of course, and we built our own, training center. We gave training to several lawyers, to several judges, and, started off mediation in a big way. As of now, I would say that maybe about 125,000 cases have been settled through mediation in these centers within Delhi. Outside Delhi, perhaps another maybe 100,000 cases have been settled through mediation, court annexed mediation. The Chief Justice of India also set up something called the Mediation and Conciliation Project Committee. And I was fortunate to be a member of that committee in 2005 when it was constituted. And later on, when I was appointed as a judge in the Supreme Court, I became the chairperson of the committee. So I've been involved with mediation in the last 15 years and have seen its development and growth. There are, various kinds of mediation activities that are going on. One, like I said, is under the aegis or under the auspices of the Mediation and Conciliation Project Committee, or the MCPC. And the idea is that, we train mediators, we assist the courts in setting up mediation centers, and encourage mediation, court annexed mediation. So that is really the work of the MCPC. The second kind of mediation that is being encouraged is, again, localized in the sense it's existing only in Delhi. The Chief Minister of Delhi, she felt that mediation is an idea whose time has come, as they say, and it should be encouraged. And so she encouraged us to set up something called the Delhi Dispute Resolution Society, or the DDRS. The purpose of the DDRS was to set up mediation centers in different parts of Delhi, mainly in the community centers. And today there are 11 such mediation centers in different parts of Delhi. They do not deal with cases that are pending in courts. It is not a court annexed mediation. It is something, if I may call it, pre-litigation mediation. So if there is a dispute, the parties can come to the one of the centers in the DDRS and try and have their dispute resolved under the auspices of the DDRS. The DDRS has kind of established itself in Delhi, and maybe in the region of about 30 or 35,000 cases have been settled by the Delhi Dispute Resolution Society. The third kind of mediation that has picked up maybe in the last, say, about 3 or 4 years is that of private mediation. This is actually a very handful of lawyers. I would not put it at more than 15 or 20 lawyers across the country who are doing private mediation. So they have their own, mediation chambers or their own mediation centers. They manage it in their offices or wherever. But that is also another area that is developing. Now, so therefore we have, like I said, 3 different kinds of entities. One is the MCPC, Mediation and Conciliation Project Committee of the Supreme Court, the Delhi Dispute Resolution Society, and the private mediations. In many states, in many states under the aegis of the MCPC, mediation centers have been set up. Many of them are doing extremely well. Many of them still need to, improve their performance. But there are a very, very large number of mediation centers across the country. And in fact, the Finance Commission gave a lot of money and a huge amount for setting up mediation centers in every district in the country. So at that time, they were in the region of about 620 districts, and mediation centers were set up in more than 300 such districts. So really, to say what is the performance of all these 300 mediation centers is difficult. But like I said, some of them are doing extremely well, while others need to pick up. We also have, other systems of dispute resolution. Ajay had mentioned something called Lok Adalat, which literally means a people's court. So you have small disputes, which are pending in courts, may not be pending in courts. The parties can come to a Lok Adalat. These are held quite frequently. In some places, they are held once a month. There's no cost attached to that. And if both the parties agree, they can, have their dispute referred to a Lok Adalat, and the decision of the Lok Adalat would be binding on the parties. We also have, of course, arbitrations that are going on. We have arbitration centers in several parts of the country. This is also being encouraged as a system of dispute resolution. Conciliation has not really picked up, although I must say that in a law passed in 1947, the Industrial Disputes Act, conciliation is one of the methods of dispute resolution between the workmen and the industry. But in spite of 70 years, conciliation as such has not picked up. It is a part of our arbitration and conciliation law, but I'm afraid it has not picked up as much as it should have. We also have the National Legal Services Authority, or NALSA. Now, they have been also given the responsibility to encourage mediation through laws. And some of the laws which have been enacted in the recent past, in the last maybe 4 or 5 years, encourage mediation. In 2013, we had something called the Companies Act. Now, that encouraged mediation, and it said that there should be a panel of mediators, and qualifications were to be prescribed for that panel of mediators. But unfortunately, between 2013 or 2014 until today, the panel of mediators has not been set up, or the qualifications have not been laid down. We also have the Commercial Courts Act of 2018. Now, as far as that is concerned, some rules were required to be framed for mediation. As the chairperson of the MCPC, I did have a meeting with NALSA and some industry, to see if we could push this forward under the Commercial Courts Act. But I'm afraid nothing much could happen because the rules have not been framed under the law. Then we also have the Consumer Protection Act, and that's at various levels. You have a district consumer forum, state consumer forum, and the national consumer forum. Here again, mediation has been made more or less compulsory, and parties are encouraged to go in for mediation. But again, you need a consumer mediation cell, as the law puts it. And again, unfortunately, the consumer mediation cell has not been set up. So while our legislature, is encouraging mediation through these 3 laws that I mentioned, the Commercial Courts Act, the Companies Act, and the Consumer Protection Act, I'm afraid, the executive branch of the government has not been able to get its act together. And the qualifications, the requirements, the rules, the methodology, centers, and so on and so forth, have really not been put in place. And I think this is one of the, pitches from encouraging mediation. So far as the future is concerned, I would say that we need to get together. Everybody needs to get together. and institutionalize mediation. There must be a regulatory body, which lays down the qualifications which are acceptable throughout the country, which take into consideration the requirements, internationally as well, and which reviews the performance of mediators to see how well they are doing. There is imparting of continuing education and so on. The reason why a regulatory body is necessary, and I think the MCPC could be a good regulatory body, is that there is nothing to prevent me as an individual to get up tomorrow and say that I'm a mediator. I would have no training. I would not know how to spell mediation, but well, I can certainly turn around and say that, well, I'm a mediator. Who is there to check me? So it is for this reason that I think we need to have a regulatory body which frames rules and so on and so forth. What is the impact of COVID-19 that we are facing now? All of you know that India has a huge problem of litigation, in the sense that we have cases pending with us for many, many years. And because access to justice has more or less come to a standstill because of COVID, the backlog is going to increase. The time taken to resolve disputes through adjudication process is going to increase. That's where I think mediation can play an important role. Where persons can be encouraged to come to mediation and see if their cases can be resolved. Something in the nature of Lok Adalat. Lok Adalat, like I said, it's a people's court. It deals with petty offences or petty cases, whereas mediation can deal with far more important cases. So not strictly in the line of Lok Adalat, but in the line that is being followed at the moment through mediation centers across the country. I think the country can take advantage of the problem that we are facing right now because of COVID-19. I look at the future of mediation with a great deal of optimism. That like I said, it's an idea that whose time has come. We need to get our act together, and this is possible only if there is leadership that is provided either by the MCPC or by the executive government or by some kind of a statutory body. And once that is done, I think we are on the way to very successful mediation. So thank you very much for your time. Thank you.
Thank you very much for those opening remarks, Justice Lokur. We will certainly circle back to some of the topics you've raised. And as a resident of India outside of Delhi, I want to also add that there are thriving mediation cultures in several cities. And quite often as lawyers, there's a growing number of people who are more keen to pick up the phone to identify opportunities to settle matters rather than to fuel the conflict. Now, with turning to Natalie. Natalie, we'd like to hear from you on the negotiation process of the SMC. I was there when the signing happened, and it was a proud moment to see that India was one of the original signatories of the Singapore Mediation Convention. And India, for those who don't know, was in fact one of the original members of UNCITRAL itself. And so the leadership that India has taken, and the fact that India being the land of Gandhi and a land of peace, it is often joked that the Singapore Mediation Convention has stolen a march over India in the identification of the country with peace and mediation. More from you, Natalie.
Thank you very much, Shreyas, for that introduction, and really good morning, afternoon, and evening to everyone. Thank you to the organizers for inviting me to be a part of this esteemed panel. I've just shared my slides. I wonder if you can see that. Okay, I'll find a way to toggle through them as well while we go through. So thank you once again for having me and for inviting me. It's good to have the opportunity to engage with people from all around the world in spite of the current coronavirus situation. I know I only have 10 minutes or just over 10 minutes to speak on the Singapore Convention and related issues from the perspective of having been involved in the process as the chair, and I hope to be able to deliver on that. I will first give a brief overview of the history of the development of the convention before speaking about its scope of application, form requirements, and grounds of refusal, and then I will wrap with brief concluding remarks. I could just go to the next slide. I might need some help toggling to the next slide if I could. I'll just continue anyway. So in this slide, which hopefully you can see, it shows just a few key points about the key landmark and milestone points in the Singapore Convention. I should say that whilst it is called the Singapore Convention, it's really a convention for everyone. So not to steal the march on any particular country, including India, or any other country around the world. As we all know, it was a development that arose out of the multilateral process, and I'll speak more about that as well during the course of the presentation. The Singapore Convention was developed in parallel with the amendments to the Model Law on Mediation, and in fact, the United States had put the convention on the table in 2014, and the text was finalized and adopted in 2018. Although it was really only in February of that year of 2018, as part of a compromise proposal, that we knew that we were going to be able to proceed with having a convention. As you've heard from Ajay and Shreyas, the convention opened for signature in Singapore on the 7th of August in 2019. And already we see 52 countries from all regions of the world have signed, including India, which signed on the day the convention opened for signature. The convention has also been ratified by 4 countries, and with the minimum having crossed the minimum bar of 3, it will enter into force, as Ajay mentioned, in September 2020, specifically on the 12th. So currently, disputing parties that reach a mediated settlement agreement, as you know, already try to seek to enforce their mediated settlement agreements internationally one way or another. They seek to convert their settlement agreement, for instance, into a consent award, and this is in order to have the settlement agreement recognized and enforced internationally using the network of 159 parties to the New York Convention. However, there are inherent uncertainties in the approach. For example, if an arbitration is only commenced after the parties have reached a settlement, in many jurisdictions, the resulting award would not be one that settled differences between the parties. The resulting award would therefore not fall within the scope of the New York Convention. Further, the New York Convention was designed for arbitral awards, and certain concepts do not sit well in the context of mediation or do not accommodate the specific features of mediation as a dispute resolution process. So what the convention does is it recognizes that a mediated process makes a settlement agreement something more than a mere contract. And so long as the requirements of the convention are met, mediated settlement agreements can benefit from the convention's recognition and enforcement framework and the ensuing certainty. They can be enforced as a sword so that the obligations in a settlement agreement are carried out, or invoked as a shield to prove that the matter has already been resolved. And the Singapore Convention is modeled on the New York Convention, and which is why you often hear it being compared to mediated settlement agreements to what the New York Convention would be to arbitral awards. So that's what the arrows on this slide, which has been kindly pulled up for me, shows. The Singapore Convention was developed in response to a lack of a cross-border mechanism for giving legal effect to international mediated settlement agreements, which was said to be a significant barrier to the use of mediation to resolve disputes. There was a survey that the IMI had conducted where 80% of respondents said that they would be more likely to include mediation clauses in contracts if there was a global mechanism in place to enforce mediated settlement agreements. So in other words, I think we can say that the convention will enhance mediation as a tool for conflict management. In the next slide, we have the scope of application of the convention. The convention was developed, as I mentioned earlier, through a multilateral negotiation process. So what that means really, when you boil it down to the figures, we had about 150 to 200 people in each session from different countries, cultures, languages, professional backgrounds. So arbitrators, mediators, government representatives, and business people, and people with different interests, different positions, different levels of experience with mediation, and different understandings of the legal issues and concepts that we had to contend with. But in and amongst all of this, we found convergence and consensus, and this would not have been possible without sterling support from the Secretariat, including Ms. Corinne Montanari and Ms. Jason Lee and Ms. Judith Naipa, who are all with us here today. Well, Judith is here on the panel. Jay, I know, is currently on the webinar with us. As well as the creativity and commitment of many delegations, and foremost amongst them the US delegation, led by Tim Schnabel, as they were the ones who first put the proposal on the table in 2014, but he remained a dynamo throughout the process, as most of you may know. So seeking and finding consensus amongst all the representatives in the session, I think really made for a stronger convention that takes into account all the different concerns that were brought to the table during the negotiations. And that brings me to the contents of this slide. You will see in the scope of application, quite simply, the convention applies to international, commercial, settlement agreements resulting from mediation, so those 4 elements. And mediation is defined broadly to accommodate mediation as a flexible process. There is no limit on the types of remedies that can be reflected in the settlement agreement, so it can include monetary or non-monetary elements. And this recognizes that in a mediation, disputing parties can design a settlement that responds to their needs and takes a holistic view of their interests and commercial relationship, and that those kinds of settlements often extend beyond pure monetary relief. I would footnote that there are 2 reservations that are permitted under this convention, and the scope of application would be subject to the permitted reservations that a signatory to the convention may make. In the next slide, we have the form requirements, which are similarly intentionally simple and straightforward, and the convention may apply so long as the settlement agreement is in writing, signed by the parties, and there is evidence that the settlement agreement resulted from mediation, which evidence can be provided by a number of different methods as enumerated in an open list in the convention. It is important to note that when the convention was negotiated, we recognized that it was not appropriate in some legal cultures to have a requirement that the mediator sign the settlement agreement, and that this be the only acceptable proof that the agreement had resulted from mediation. And that is why the types of proof that the convention provides for is reflected in an open list. The next set of issues is the grounds of refusal, which is in the next slide, and the grounds of refusal are limited to those set out in the convention. So you'll see that they include where there was incapacity of a party to the settlement agreement, or if the settlement agreement was null and void, for instance, because of fraud or misrepresentation. And these grounds of refusal here, and I will move to a next slide later, they are tailored to the practice of mediation, retaining the successful elements of the New York Convention in their specificity, in their exhaustiveness, whilst responding to the difficulties posed by seeking to translate grounds of refusal of enforcement in the New York Convention to the mediation context. And on the next slide, moving past subparagraph D, we have E and F that are grounds that are specific to mediator misconduct. And these grounds of refusal really were one of the most difficult issues that we had to deal with when drafting the convention. They were extensively negotiated, and as some of you may know, I have shared how the consultation breaks and corridor negotiations for these grounds of refusal were some of the longest we had for any of the issues that we had to discuss. And in its final form, the enforcement of mediated settlement agreements may be refused where there was a failure to disclose on the part of the mediator, which had a causal effect on the disputing party entering into the settlement agreement. The intention is for the ground of refusal to apply only in exceptional circumstances. And during the negotiations, nobody doubted the importance of ethics. Nobody doubted the significant role that mediators play in enabling a settlement agreement to be reached. But the issue rather was whether these should be the subject of specific defenses or whether they should be addressed by other grounds of refusal that were already provided for in our drafting, such as null and void, public policy. And we also had to ensure that when we drafted these provisions, objective terms were used that could be understood in different legal traditions to minimize the risk of opening the door to satellite litigation. So the long and short of all of that really is how we see now the focus in the grounds of refusal here being on whether disputing parties' agreement to the mediated settlement agreement was vitiated by mediator misconduct. So that's my whirlwind tour of the convention and its negotiation process. The next slide is simply one on concluding remarks, of which I just have a short set of concluding remarks on what the Singapore Convention means for users of dispute resolution. In short, I think the convention will make mediation a more meaningful, effective, and viable option for the resolution of international commercial disputes. It will broaden the suite of options available to users of dispute resolution, depending on the subject matter of the dispute, the urgency of the situation, the relationship between the parties, and other factors. Disputing parties may choose litigation, arbitration, mediation, or some combination of these to resolve their dispute. And with the Singapore Convention, I think now users will know that there will be certainty in the recognition and enforcement of the outcomes of their chosen method of dispute resolution that is pursued, including mediation. Of course, the mechanism that the convention offers will be more effective and useful as more and more countries sign on and ratify it. And I certainly hope that more signatories and ratifications of the convention are on the cards in the near future. Thank you.
Thank you very much, Natalie, for your comments and, as you said, a whirlwind but comprehensive overview of the negotiation process of Singapore Convention. I now turn to Dr. Judith Neiper. Dr. Judith Neiper is going to speak to us on UNCITRAL's international mediation framework. Over to you, Judith.
Thank you very much. And thank you to everyone who made this webinar possible. From my perspective, it's indeed a very timely webinar for several reasons. The first, of course, being that UNCITRAL finalized its important pieces of work in the area of enforcement. We just heard about the Singapore Convention. The second reason is, and I'm very grateful to Justice Lokur for the explanation of how vivid mediation culture is in India. And the third reason, and here I very much agree with you, Justice Lokur, that mediation might be a particular useful tool to respond to the current COVID-19 crisis. Because what is needed every day, everywhere from us now is flexibility, also in the area of dispute settlement. And flexibility is the essence of mediation. So it's a useful tool in these times of crisis. So before presenting you, it was already said several times by Ajay and also by Atit. Am I able to? Yes, I'm able to change the slides. So just as a reminder what UNCITRAL is, it's the core legal body of the United Nations mandated to harmonize and modernize international trade laws since its establishment in '66. And what is so special is the unique drafting process, which is really based on inclusiveness. Natalie already explained. The attempt is to be universal. So the 60 member states are chosen from the different various regional groups to make sure that every geographical region, every level of development, every legal system is properly represented. And that's key to the UNCITRAL process. By the way, India is a very active member state since 1968. So there's a long tradition between UNCITRAL and India India is very active in all of our 6 working groups. In addition to the member states, we do invite all the other United Nations member states. So we do send out to every working group session, to every commission session, we do send out 193 invitations. I'm stressing that because it shows that every state that has an interest in a given legal topic is entitled to participate. The difference between a member state and a non-member, UNCITRAL non-member state, is only the right to vote. But in our history of more than 50 years now, we never voted on a question of legal drafting. We try to reach consensus, even if it takes very long time. And as Natalie said, informal discussions play a big role here, including corridor discussions and sandwiches that are shared by all the delegates. The mediation texts that we are discussing right now have been drafted by around 90 states and around 40 to 50 IGOs and NGOs. That's a lot of people. Natalie gave the figure between 150 and 200 that really discussed all the technical details of the convention, of the update of the model law. In addition, the discussions were held in the 6 United Nations languages. Why am I stressing all of that? I think it's important to understand the texts. It's important to understand why they do fit into the different legal frameworks. And it's important when trying to understand these texts, when reading these texts, when doing the interpretation of these texts. And you can, the drafting process is very transparent. So you do find all reports of the working groups of the Commission. You find them on our website, and you can capture the whole discussion, the whole formal discussion. We are, of course, not reporting on informal discussions on the corridor, but the formal discussions are fully captured and are available to everyone, including, by the way, audio recording. So if you have several weeks of holiday, you might wish to listen to all the original discussions relating to the drafting process. Here you have a picture of working group 2. Everyone looks tired but happy, and this is why this picture was taken just when all the texts, the 2 texts were finalized. So everyone was relieved that a compromise, a constructive compromise could be found, even in those areas where we had really big discussions and tried to find the best solution. What did we have before? Because I want to expand a little bit and talk about the whole framework of UNCITRAL. So UNCITRAL started as early as 1980 to work on conciliation. By the way, you see that Natalie was stressing mediation, and our new texts are called mediation texts, mediation instruments. This is because the term conciliation and mediation in the UNCITRAL context is used interchangeably. We decided at the Commission session in 2018 to take as a lead term the term mediation and not conciliation, because in many countries the term mediation is better known, and this is why we switched terminology, but without changing the concept. So the concept, the UNCITRAL concept, to use both terms interchangeably did not change. It's always a process by a third party, not entitled to impose a solution, but trying to facilitate the negotiations in a dispute. By the way, the Indian Arbitration and Conciliation Act from 1996 is largely inspired by these conciliation rules. Then we have the UNCITRAL model law from 2002, which went one step further and took as a basis the contractual rules, the conciliation rules, but went a step further to make it a legal a legal framework text, a law, which contains the main elements of the mediation procedure from the beginning till the very end, and including various issues such as confidentiality, such as party autonomy, such as fair treatment. And the text seeks to strike a balance between the protection of the integrity of the conciliation process and the still providing the maximum flexibility to preserve and the preservation of party autonomy. When preparing this draft in 2002, UNCITRAL discussed whether it would be desirable and feasible to prepare a uniform model provision on the enforcement of settlement agreements resulting from mediation that would be universally acceptable, and UNCITRAL at that point in time came to the conclusion that the national enforcement systems are too diverse, that no consensus was possible. Now, approximately 20 years later, we have exactly these provisions that were said to not be possible. Indeed, what we have now, the UNCITRAL package, is still the conciliation rules. The model law from 2002 updated, which contains a section on enforcement and which reflects exactly the Singapore Convention, the text of the Singapore Convention. There are deviations in the text only when it's necessary, because the legal nature of the text requires a different wording. And by the way, I think this mediation law, which I'm calling very shortly mediation law, is a law that could compete to get a prize for the longest title. And I'm reading it only once because otherwise we would need to prolong the webinar. The title is indeed UNCITRAL Model Law on International Commercial Mediation and International Settlement Agreements Resulting from Mediation 2018, amending the Model Law on International Commercial Conciliation from 2002. Yeah, so then the third text we have, and which has a slightly more convenient title you can see on the PowerPoint, is the United Nations Convention on International Settlement Agreements Resulting from Mediation, and which has already been presented very comprehensively by Natalie, which establishes the legal framework for the right to invoke settlement agreements as well as for their enforcement. I want to shortly mention that to make the framework by UNCITRAL complete, we are currently working on a number of drafts. So you see here in the bubbles a number, and this number is the reference number under which you will find the text on our website. We have first the draft of the mediation rules, which is an update of the conciliation rules from 1918. And the idea of updating it is to try to capture, so to do the update in light of the new instruments, and also to reflect the development of mediation in the last 40 years, the conciliation rules being from 1980. Then we have the notes on mediation. The notes it's not a binding instrument, it's rather an explanation, a checklist. Taking the model, we have already notes in the area of arbitration, so we thought it might be useful to describe relevant issues that might come up in a mediation and to give kind of introduction to parties, to mediators, to various stakeholders, so that they know what elements have to be taken into consideration when thinking of mediation. And the third text that we are currently drafting is the guide to the enactment and use of the model law, which has been updated according to the updates of the model law. Here you have a short visual presentation of what is included in the mediation notes, and this is only to tell you that I would never be able to tackle every point in this short webinar. but as already stated, you find all the information on our website. So what should become the cornerstone of mediation is, of course, the United Nations Convention on International Settlement Agreements. We already stated that a number of times, but there are certain things that cannot be repeated often enough. So the date of entry into force is 12th September 2020. And here you have a map which shows the signatory states as of today. 46 of these states did sign at the signing ceremony in Singapore on 7th of August last year. And we have already 4 of the ratifications, and only Saudi Arabia has raised a reservation, which is the reservation that states can exclude agreements with government agencies and persons acting on behalf of an agency by being a party. So the state reservation, if I might call it that way, has been raised, but only by Saudi Arabia. So the other 3 countries did ratify the convention without any reservation. Just again repetition, but again repetition that cannot be done often enough. The idea is to model it after the New York Convention, and we do hope, of course, that the Singapore Convention becomes as successful as the New York Convention. I think the start was extremely successful, much more successful than the start of the New York Convention. So if we take it from there, I think someone said today the golden age of mediation may be already at our doors. What is important is flexibility, and that the needs of the parties are trying to be taken care of. The approach is a very holistic approach and covers legal, non-legal issues, and this is the beauty of mediation, which the convention, of course, tries to preserve. Here, a little reminder of the model law. So you have, as a basis of the model law from 2018, you have the model law from 2002, which outlines the mediation procedure from the beginning till the end. And then you have, as one edition that was now drafted together with the convention, and this is section 3, which follows the convention. The Indian law, being very much in compliance with the conciliation rules, which is the basis of the model law from 2002, would not have great difficulties to adapt to that model law, because it will not be a huge departure from what India already has. The main need is obviously to include the new section 3. And I heard that the Supreme Court of India already has formed a panel to work on a draft bill. So we are very much looking forward to that outcome. As a summary, maybe once more, the whole UNCITRAL mediation framework. So you have the conciliation rules, which are currently in the process of being updated. You have the model law that has been updated and includes a section on enforcement, plus the guide that is currently being updated. You have the United Nations Convention on International Settlement Agreements, the cornerstone to be in mediation, and you have the draft notes of mediation, which you could already consult on our website. And with that, I would give it back. And if you have further information, you can, of course, always contact us, or you can have a look at our website, where you have all the information outlined quite comprehensively. Thank you very much.
Thank you very much, Judith, for that very comprehensive presentation and it's a challenge to present technical information with humor, the way you weaved it in. So thank you especially for that. We now come to the bottom line, which is led by Nadia Alexander. Nadia is addressing herself to the question, why mediate at all? So you've heard from the various speakers, you know what is out there, but this is addressed to the users. And amongst the audience, I note that there are many students, many practitioners of varying degrees of proficiency in mediation, and indeed in-house counsel and users. So over to you, Nadia. Why should anyone mediate?
Thank you. Thank you. I'm very pleased to be here, and thank you so much to the organizers for inviting me and allowing me to be part of this virtual meeting with people from all over the world. I want to start with a poll, but it's sort of got to be like a silent poll, I guess, because you'll just have to think the answer to yourself. So, which dispute resolution mechanism do you think is most popular amongst legal users? And by legal users, oh, I've got this, sorry, I'm just going to try and minimize this. Sorry, you can look at my, there we go. Is that, hopefully that's better. Let me know if, okay. And by that I mean lawyers and legal advisors, right? Not corporate decision makers or in-house counsel. So put the answer in your mind. And then I'll tell you what a survey what the findings of a survey were at SIDRA, the Singapore International Dispute Resolution Academy. And it's probably no surprise when I tell you that in international circles, the most popular, the most used dispute resolution mechanism in cross-border settings was arbitration. All right, let's start with an easy one. Now, what do you think is the most important factor influencing legal users' choice of dispute resolution mechanisms? Again, the setting is cross-border and commercial, right? So put the answer in your mind, and I'll tell you what we found. That, again, probably not a great surprise for legal users. It was different for client users. For legal users, it was enforceability. And by that, we mean having an expedited enforceability mechanism available. And there's a clear link between that and arbitration being the most used process. But what about client users? And by that we mean in-house counsel and also CEOs, corporate decision makers. What do you think the most important factor influencing their choice of which dispute resolution mechanism they were going to use? Right? What would that be? Well, it wasn't enforceability. It was neutral. Okay, was having an impartial neutral, right? So the impartiality of the neutral, and I guess it follows of the process, was the most important factor for client users. Now, going back to question one, arbitration was the most used, most popular process amongst legal users. Where did mediation fall? Well, the second most popular in international setting was litigation, and the third most popular was mediation, but it was pretty much tied with the use of hybrid processes. So what happens, and do the statistics on the use of mediation change if we include mediation in hybrid processes? So often we think about mediation as a standalone, and obviously it is a standalone process. But we sometimes forget about how much mediation is being used within other processes, such as arbitration processes, med-arb, arb-med-arb, or similar processes. So where do you think mediation would rank if you combine it with hybrid processes? Well, the answer is it moves from third, equal with hybrid, up to a second, close with international litigation. So I think that's an interesting finding, showing that there is possibly more use of cross-border mediation than we think if we're looking at standalone processes only. So before I talk a little bit more about why mediate from a user's perspective, drawing on the findings of this survey, I just wanted to say that when I'm talking about mediation, I want to shift the lens from a strictly dispute resolution lens, which can be narrow, particularly with from a legal perspective. I want you to think about it as a decision-making process. I want you to think about it as a risk management tool, right? And maybe you do that already. And that's certainly how clients think about mediation, and that's what we've found. So let me tell you a little bit about the survey. At UNCITRAL, what we wanted to do is we wanted to find out how businesses, corporates, how those people make decisions, and how their lawyers advising them make decisions about which dispute resolution process to use in cross-border disputes and why they make those choices. So we rolled out a survey last year, and we asked them about disputes they actually engaged in between 2016 and 2018, right? So just a few words about the survey. We only spoke to users, legal users and client users, nobody else. We based it on their use of IDR, which is my acronym for International Dispute Resolution, so arbitration, litigation, mediation, and hybrid procedures. And if they, if the respondent didn't have experience with one particular procedure, then they didn't answer questions about that, right? So it's really based on people's experience. And we also distributed the survey in the 6 languages of the UN. So let's have a look at a couple of these findings, and I think they're really enlightening to why mediate and what are the benefits, if you like, or features of mediation as a standalone process or as a hybrid process that can be appealing or attractive. So you'll see here up the top, the most used, most popular process in cross-border settings is arbitration. But have a look at the difference between, I don't know what color it is on your screen, but for me it's like gray and gold. The gray is the lawyers, the gold is the clients. So lawyers are a lot more committed to arbitration than their clients are. That's one of the first points I'd make. The gaps between client preference and lawyer preference are less, particularly when you get down to the use of mediation and hybrid dispute resolution processes. You also see here that if you add together the use of mediation as a standalone and within hybrids, which was part of the definition, that the use of mediation increases dramatically. Well, what happens when we dig a little bit more deeper into mediation itself? So I wanted to present some of these findings in the context, not in a vacuum, but actually in the context of other dispute resolution processes as well. So if you look at this graph, what you'll see is that there are sets of, it's a bar graph with sets of 3, and the middle, sort of the middle bar refers to mediation. So here you see that enforceability, having an expedited enforceability mechanism is very important for those who chose mediation, right? What was their reason? Well, number one was having this enforceability mechanism. It was less important for people who chose mediation. Why? Because they were choosing mediation because they likely, in most cases, expected there to be compliance provided there was settlement. They saw the risk of, I guess, non-compliance as a small risk, and they saw other factors as more important, and we'll look at some of those other factors later. You'll also see the factors of impartiality and neutrality, important all around, but most important in relation to mediation. Finality, less important in the choice of mediation. Why? Because if you don't reach a settlement, it's not a final outcome. Speed and cost, no surprises. Why would you go to mediation? Faster, more cost effective. Now, this is why people chose mediation and also other processes. How satisfied were they with that? And I think this is really interesting. Overall, if you were to look at these two graphs closely, you'd see overall a bit of a drop, right? People are less satisfied with these particular factors compared to what their expectation was. And personally, I put that down to the fact that I think people like to complain more than they like to praise. But what's really interesting is where you see the big drops. And you see the big drops more in relation to arbitration and sometimes litigation, and you actually see much higher satisfaction with mediation processes and with mediation factors across the board, whether it's on their expectations about enforceability and their experience of it, their expectations on impartiality and their experience of it, their expectations of finality, speed and cost compared to their experience of it. And you'll see some big drops, particularly in relation to speed and cost in relation to arbitration, that the experience or the satisfaction level did not meet the expectation in relation to arbitration, but you don't see that drop in mediation. So let's take a shift, because we've got 100 pages of this survey, and I've just pulled out a couple of slides for you tonight that I thought might be interesting. If we look at the factors influencing the choice of mediator, not mediation, but move to how you would choose a mediator, I think this is a very interesting finding, because number one, with a close second of experience, but number one is good ethics. And I think this is so interesting, bearing in mind what we've heard about the debates within in UNCITRAL leading up to the Singapore Convention and the grounds of refusal, which link to mediator conduct. The importance of ethics. I know there's a lot of discussion now about mediator code conduct, etc. And users, certainly client users and legal users, put this up there as a very high, very high importance. But if you look at the percentages, right, this is a bundle of factors: ethics, experience, language, efficiency, industry knowledge, right, cultural familiarity, and cost. Right. Interestingly, from a user perspective, less important were, but not unimportant, but less important were formal qualifications, and that the mediator needed to be someone from a third-party country, not from a country from one of the parties. And I think that that last point really highlights some of the fundamental differences between mediation and arbitration. And how satisfied were they? Well, again, there's always a dip, I find, with satisfaction, because people always like to say things could be better. But again, by and large, people are highly satisfied with their choice of mediator. And there's only a small gap between expectation and experience here. And actually, finally, or not finally, depending on my time, I found this very enlightening. So this is a finding from all users, clients and lawyers put together. So we asked them, when you chose a hybrid dispute resolution mechanism rather than arbitration, why did you do that? Why didn't you just go straight for arbitration or straight for mediation? Why did you choose a hybrid? And you can see the number one answer by quite a bit is preservation of business relationship. And, we talk about that, we know that, anecdotally people talk about that all the time, but here we have users, clients in cross-border disputes telling us this is why we would use a hybrid. Why not mediation? Because they would be concerned, or particularly the legal users were concerned about the absence of an expedited enforcement mechanism, which we know is now coming into place with the Singapore Convention. Of course, remember that this survey asked the respondents questions about disputes they were involved in between 2016 and 2018, well before the Singapore Convention had been articulated. And then we said, well, why not just use mediation? Why would you use a hybrid rather than mediation? And the number one answer here, well, there was cost and efficiency. And we had to think about this. We thought, well, what does it mean? And by efficiency, what we found with some follow-up questions was users meant, well, if the parties don't settle, it's efficient because we can go straight into the next part of the hybrid process, for example, arbitration, right, or neutral evaluation or something else. And also in terms of cost overall, right, it's more efficient for that same reason. We don't need to stop and then go and start a new process, right? And also enforceability is a factor as well. So I'm not sure what my time is like. Shreyas, if I've
I
got
think we have a couple, maybe a minute or so.
Okay, okay. I can finish in a minute. We asked people questions about investor-state dispute settlement. And in particular, again, only people who are involved in investor-state disputes got to answer these questions. And it was a very small sample, I have to say. But what was really interesting, I thought, was if you look at the client users versus the legal users, there is certainly interest in mediation. Ad hoc mediation is used more than institutional mediation. That's probably not surprising because institutional mediation is not found as commonly in investment treaties. But you don't find that mirrored amongst the legal users. When we asked these people who'd been involved in investor-state disputes, what about reform, right? What do you think? If you look down, this is the client users, 80% of them said the ability to use mediation, right, would be a very good reform, right? Followed then afterwards after that, the ability to use hybrid processes, 67%. And the lawyers, yeah, 48%, not 80%, but 48% said the ability to use mediation. So I think we've been talking about the golden age. It's been a thread through the various presentations, and and I think what we found in our study, like why, if you ask the why mediate question, that wasn't the purpose of the study, but if you try to ask that out of the study, is that we are on the cusp of unlocking mediation's golden age. Thank you.
Thank you for that. Unfortunately, ladies and gentlemen, panelists, we have a hard stop in about less than around 10 minutes from now. So I think there's a plethora of questions that have come in. I don't want to lose the opportunity of presenting those to the panel. May I quickly begin and request the panelists to keep your comments to maybe a minute or two. Judith, there's some debate amongst the audience as to whether at all a new law is required and how much legislation is going to come in the way of the initiative and the inherent flexibility that mediation requires. And so there's some apprehension around boxing in the creativity of mediation through legislation. And secondly, this is a lot of it is lawyers talking to other lawyers. And how do we give voice to the non-lawyer community, even amongst not only users, but even potential mediators also? Judith?
Yes, so what the UNCITRAL text try to do is to guarantee the process, but still enable flexibility. So the cornerstone of the processes are legally regulated, but the whole range of flexibility should still be possible. This is exactly the point, and that's why the instruments are drafted very differently than those in the area of mediation. What we tried to put together in the notes is explaining exactly that, how you could use mediation, how to nudge people towards mediation. So the law is just a framework that should enable parties to have their creative solutions, to have the open discussion that is very much needed to become creative. You need to have certain security in place, for instance, regarding confidentiality. And for that, it was the view of UNCITRAL that certain elements need to be regulated in the law. But what you have now in the Indian law is already quite close to the model law from 2002. The only thing, the only aspect that really needs to be regulated in addition is the section on the enforceability. And here, yes, again, I think you need a legal basis. And we know that India signed up to the convention, and now you need to implement that convention, and therefore I presume that you would need a legal basis, which is of course something that needs to be answered by each state individually.
Thank you for that comment. And very quickly, in about half a minute, if possible, on the role of non-lawyers, if you could speak to that, and then I'll go for a question to Natalie.
Non-lawyers are very important because they have maybe less this adversarial thinking that we try to have in mediation. So legal knowledge is very often important, but creativity is also very important, and not being bound by legal rules. This is probably what lawyers need to do, and what non-lawyers are more able to do, because they don't have that package with them and can be creative from the very start.
Thank you for that. Natalie, a couple of questions on the convention itself. I know that time is limited, but there is concern around Article 2.3 itself, the definition or the narration of description of mediation as being a process where the neutral lacks the power to impose a decision. And that seems to lead to some confusion as to whether that ultimate conclusion resulting from a mediation is binding or not. That's one nature of question. The second set of questions that have come up is around whether you can challenge a settlement at all. That's a concern, and I know the convention speaks to it. And finally, on whether there can be changes or innovation to an agreement that has been arrived at. So technical questions around the convention, but I'm sure you'll quickly rise to the challenge. Thank you.
Thanks very much, Shreyas. Those are really good questions, and it shows deep thought that everyone's been having on the convention text, which is what we do need for robust implementation. So on the first question, the reference to lacking the authority to impose a solution on the parties to the dispute was simply to distinguish from the situations where, for instance, you have a third-party adjudicator who comes to a decision on behalf of the disputing parties and confers the outcome upon them. Whereas in a mediation, as we know, the disputing parties themselves reach a decision on what the resolution of their dispute should be. And that is the intention of that language. It's not intended to suggest that the outcome of the settlement is not to be binding. As you know, the convention is in fact seeks to support the binding outcome of a settlement process for the mediated settlement agreement to be recognized and enforced or given effect to across borders. So hopefully that gives comfort to those who have concerns over Article 2.3. And then with regards to whether or not you can challenge a settlement agreement at all, that is in fact the raison d'etre behind why we had all those negotiations over the grounds for refusal. It is to enable, in certain limited situations that are enumerated in the convention, for if you want to look for cross-border application of the settlement agreement, to refer to these grounds for refusal, which allow a disputing party to trigger and say there are certain grounds that have been met here, and for these reasons we should not be recognizing or enforcing, invoking this settlement agreement in a particular jurisdiction. There's also the possibility, like in the New York Convention, for a court for themselves to proactively refer to some of the grounds of refusal, and that's also provided for in Article 5. But as for change, the last question, very quickly, I'll just deal with it, on changes to the settlement agreement afterwards. If the settlement agreement has been subsequently modified, Article 5.1b 3 has a ground of refusal that addresses that. So the idea is that the ultimate, the end point of the settlement agreement is what should be relied upon in the enforcement process, and not for the disputing parties or the parties to the settlement agreement to refer to prior iterations of the settlement agreement and seek to refer to the prior iterations instead. So hopefully I've managed to address these questions. Thank you.
Thank you, and that was in great time. With apologies to Nadia, if I may, please, Nadia, because we are so short on time. There are a series of questions on India, and I would like to please address them to Justice Lokur. I'm not sure if we'll have further time. beyond that. So with that, Justice Lokur, there are a lot of questions around the culture of mediation. Yes, there's legislation and all of this, but the question of mindset and culture is one that seems to be troubling many of the questioners, as well as the need to have training and creating a database. And there's also a small observation made that in the Companies Act has in fact, the rules have been framed, and the Ministry of Corporate Affairs has in fact notified a panel of mediators. So the question is on the need for training, the databases, and introduction of mediation into the legal curriculum in India. Over to you, sir. What are your thoughts?
Well, training is definitely very, very important. And you see, the experience that I have is that it's not that, because I've been trained now, it's good for the rest of my life. It's not like that. This is a developing art. It's a developing technique. There are a lot of things that keep changing. So really, training is important, and that's why I had mentioned about continuing education. So maybe after 1 or 2 years, there should be refresher training. Cultural issues are also very, very important. We found that in some parts of India, hand gestures have a completely different meaning from what they would in other parts of India. So I think that is also extremely important. Language is very important. In some of the rural areas of the country, we have been told by the mediators who have gone there that the litigants, the users, they say that we would like to have somebody who can speak our language, rather than English or Hindi, somebody who can speak our local language. So really, there are a lot of things that are involved in this, and it's not something that is static. It is something very, and we have to be alive to that.
Thank you, and so sorry to the panelists for cutting it short, but there are many other exciting questions like mandatory mediation, which we could not get to. I would be failing in my duty if I do not convey my wholehearted thanks to Ajay Thomas for all his efforts to put this together. Thank you very, very much, Ajay. And thank you to Live Law again. Thank you, Justice Lokur. Thank you, Judith, Natalie, Nadia, and also to Adita, and everyone at UNCITRAL and RCAP. And a quick plug-in about UNCCI. We were established as one of 3 national coordination committees after Japan, Australia, and India. And in 2016, we had a conference addressed by His Excellency, the President of India, launching UNCCI. And the effort has been to disseminate information on UNCITRAL. And I'm delighted this webinar has progressed that by some length. I bid you all safe and good times, and thank you to each member of the audience for dialing in. Thank you very much.
Thank you. Thank you.